Collegium system is alien to the Indian Constitution.
On the collegium system,
Collegium system for appointing judges has to go.
Collegium system, a unique system that exists in no other democracy but India. What is that system? Let's take a look with an example. In 1979, the then Chief Justice of India, Justice Y.V. Chandrachud, recommends B.N. Kripal as a judge of the Delhi High Court. Justice Kripal, who goes on to become the Chief Justice of India, recommends the name of Justice Y.V. Chandrachud's son, D.Y. Chandrachud, as judge of the Bombay High Court in 2000. Justice D.Y. Chandrachud, who is the current Chief Justice of India, has now recommended Saurabh Kripal, the son of B.N. Kripal, as a judge of the Delhi High Court. This system, where a closed group of judges appoint themselves, each other and their family members as judges, has come to signify the collegium system in India. As seen in the above example, the system promotes nepotism, where sons and nephews of previous judges or senior lawyers are appointed as judges. It has also been called out for its non-transparent and opaque functioning. A collegium comprises of the CJI and 4 senior-most judges of the Supreme Court, which recommends a candidate to the government to be appointed as a Supreme Court judge. The government may return for reconsideration by the collegium, but if the collegium reiterates its recommendation, then the government is mandated to appoint the respective person. For the High Court judges' appointment, the names recommended by a collegium of the Chief Justice and 4 judges of the High Court are sent to the government after the approval of the Supreme Court Collegium. This system of judicial appointments has been justified by the Supreme Court, citing judicial independence. The doctrine of judicial independence that forms part of the basic structure of the Constitution is borrowed from the United States of America. But even in the United States, where there is a strict separation of powers between the 3 arms of the state, the executive and the legislature play a vital role in the appointment of judges of the Supreme Court. In the US, the president nominates candidates to be appointed as judges of the Supreme Court, who are then subjected to a confirmation process through the Senate Judiciary Committee. The Senate Judiciary Committee prepares a report indicating the candidates as positive, negative, or neutral. The nominations are then referred to the entire Senate for voting, which confirms or rejects the nominations through a simple majority. In the case of the UK, although the legislature plays no roles in appointments, the Lord Chancellor, who is a member of the cabinet, plays a pivotal role in the appointment of a judge. The Lord Chancellor is given the option to reconsider or reject a candidate. However, in India, the judiciary, which wields the power to uphold the rule of law and ensure justice for people, stays completely insulated from being directly or indirectly held accountable to the people. The collegium system is nowhere mentioned in the Constitution and has been evolved by the judiciary itself through 3 judicial pronouncements. When the Constituent Assembly was debating the provisions of separation of executive from the judiciary, T.T. Krishnamachari, an eminent Congress leader, said, "It might be that by giving the judiciary an enormous amount of power, a judiciary which may not be controlled by any legislature in any manner except by the means of ultimate removal, we may perhaps be creating a Frankenstein monster which could nullify the intentions of the framers of the Constitution." Constituent Assembly members like Shibban Lal Saxena moved an amendment to make appointment of judges subject to confirmation by 2/3 majority of both houses of the parliament in a joint session. K.T. Shah wanted confirmation by the Rajya Sabha, similar to confirmation by the Senate in the US. But Ambedkar struck a middle course by making it mandatory for the President to consult the Chief Justice of India, adding that this provision may be regarded as sufficient for the moment. However, the judicial appointment system was abused by Indira Gandhi during the emergency period. This led to the judiciary to evolve a process to establish judicial independence. But this system has turned out to be innately undemocratic, with no means of making the judiciary accountable. That's why the Government of India brought in the 99th Constitutional Amendment to replace the Collegium with the National Judicial Appointments Commission. The NJAC, comprising of 3 judges of the Supreme Court, a central law minister, and 2 civil society experts, would have put in place a more transparent process of the appointment of judges. The bill was unanimously passed by the Parliament and received the President's assent. However, it was struck down by the Supreme Court in 2015, upholding the primacy of the Collegium. The issue has once again come to light, with Vice President of India Jagdeep Dhankar terming the SC's scrapping of the NJAC as severe compromise of parliamentary sovereignty. Asserting that the NJAC bill had unprecedented support of Parliament and members unanimously voted in its favour, he said there is no parallel to such a development in democratic history where a duly legitimised constitutional prescription has been judicially undone. A private member's bill has also been introduced in the Rajya Sabha by CPIM's Bikash Ranjan Bhattacharya to regulate judicial appointments. It is pertinent that the Supreme Court finds answers to the following questions. Isn't it antithetical to the idea of democracy to have a completely unaccountable judiciary? Can we let it be this way for eternity? The other two pillars of our democracy, the executive and the legislature, have plenty of checks and balances. It is high time that the judiciary also undergo a reform that will allow for a more transparent and accountable appointment process.